Hello friends, Namaskaram. How are you? Myself is Dr. Jineesh Soni. I am an advocate and a defense counsel. Copyright Act violation or trademark Act violation might cause a trouble for you. But despite of that, if you want the anticipatory bill, then you have to follow these certain protocols to stand your defense before the concerned court. In absence of specification, you could not be succeeded. Because while moving for the anticipatory bail, you have to specify to the honorable court that the allegations are false. So basically, we have to understand the fundamental, we have to understand how to proceed, and we have to understand the recent legal position in consequence of which we could be succeeded as well. So directly we are moving on the screen. I request all of you to maintain a proper notebook with pen or pencil so that you could maintain your information. And after that, if you are having any grievances, then try to apply the solution to your grievances so that you could have solution and could be succeeded accordingly. So it's a time to move on the board. The fundamental problem is that how to get anticipatory bail concerning offenses of copyright. Is it possible? If yes, then how to proceed? Concerning anticipatory bail regarding offences under copyright, we are having the recent judgment of Honorable Punjab and Haryana High Court. Judgment is dated 12th of March 2026 plus 24th of Feb 2026. In both the cases, anticipatory bail is given to the concerned accused. In the case at hand, the accused had been charged as per the protocol of section 63, 65 of the Copyright Act. Along with copyright, section 318 of BNS is also imposed. At inception, accused got interim bail, and finally it is absolute by the court. So basically, whenever we are going to move for the anticipatory bail, even though concerning the offense of copyright or trademark, we must keep in our mind section 482 of BNSS. It is concerned with the special power of High Court or Sessions Court to incline anticipatory bail. But to get the anticipatory bail, two conditions are important. Offense must be cognizable, and you have to specify that the offense is false. And in the false offense, the concerned IO is willing to arrest you. So basically, you need shelter from the honorable court. We must keep in our mind the basic rule is of bail, not jail, and it is approved by Honorable Supreme Court of India. So basically, offense is required to be proved by the prosecution. For that, trial is must. At the stage of arrest, the police is bound to follow section 35, subclause 1, subclause B of BNSS. Because Honorable Supreme Court, in its judgment, specification is Arnesh versus State of Bihar, observed that the arrest should not be mechanical. The power of arrest is one thing, but exercise of power must be justified. If it is found that it is mechanical, in that scenario, the arrest is required to be declared as null and void. In addition to this, the police has to specify that regarding the proper investigation to prevent the accused from tampering the evidences or causing disappearance of the evidences, the arrest had been done. And apart from that, it was done just to prevent him from flee away from course of justice. If the specifications are not on the record, and if specifications are not supported by any corroboration, and even specific reasons are not recorded, then accused could have the benefit. And apart from that, the police must ensure the due compliance of section 47, 48 of BNSS. And apart from that, as far as the offenses of copyright and cheating are concerned, the maximum punishment is up to 7 years. So as per guidelines, the accused is eligible to get the benefit of section 35 subclause 3 of BNSS, which correspond to section 41A of CRPC. So basically, if the benefit is not inclined, everything must be supported with specific reasons. If the reasons are not on the record as per section 393 of BNSS, then we could have the benefit. So basically, the basis of anticipatory bail is your cooperation. So while moving for the anticipatory bail, follow 5 important steps to get success. Number 1, read the FIR and ascertain your role. If your role is not specific, it is general, you may have the benefit. It is plus point for you. Number 2, give the proper explanation to FIR, to the concerned IO. It is called giving the representation. It is must, in which you have to specify that why a case is false. Number 3, you have to give notice to the concerned IO regarding the compliance of section 35 subclause 3 of BNSS. And if you visited the PS, please maintain the proof. If you are going to move for the anticipatory and you are having document with you, which I specified to you at point number 2 and point number 3, the chance to get the anticipatory bail will be on the dominant side. Because if your facts are uncontroverted and IO is showing no willingness to investigate, then we could have the benefit. And last but not least, if you are moving before Honorable High Court as per section 5 to 8 of BNSS, then it is also permissible. Because we have to chalk out the abuse of process and we have to chalk out the infringement of our rights. So in that way, we could be succeeded to get the bail or the specific remedy as per law. So while moving for the anticipatory bail, we must keep in our mind the judgments which I specified to you, and we have to follow the step which I specified to you. See you in the next video.